Coates will be aware about, he will be aware of that, I'm quite sure.
Yeah. There are some others involved in this investigation whose names won't be mentioned that pretend that we're not interested in those other cases that have been raised. But this commission has always been interested in comparing the actions of the new Black Panther case and any others. Perez mentioned 3 or 4 others in his prepared testimony. We've heard others. There's one in Mississippi in 2005, Orange County, California, Grand Coutru, Louisiana in 2006. Is it fair to say that you know, there were other attorneys? Were you personally involved in any of those other cases?
I was involved in none of them.
Okay.
Coates, however, would be able to answer questions about those cases.
Okay. I desperately want more information from the department. It's absolutely central to our original investigation, and the implication that we don't want to compare apples to oranges or apples to apples, as the case may be, offends me. But thank you for identifying that. Another reason for the department to allow Coates to testify again to this commission. Finally, I want to end where I said I kind of wanted to begin to explain. You are not testifying to matters that are deliberative, but deliberative process is a subset of the president's executive privilege. And as we and the commission have explained to the department time and time again, the Supreme Court in U.S. v. Reynolds says that executive privilege is not to be lightly invoked, but it must be personally invoked by the president or the department head. And we finally heard only the night before Perez testified that it has not been invoked. And as far as I know, it hasn't been invoked to this point. And yet the department's position is that even though it has not invoked executive privilege, it can simply refuse to comply with the commission's request. Is that the way it's been communicated to you, or do you have some other understanding of their position?
My understanding of their position is they've not invoked executive privilege. My understanding of their position is that they have interpretations of deliberative process that seem to be inconsistent with previous interpretations by the Office of Legal Counsel inside the Justice Department. That is one of the reasons I'm here today. Okay.
Well, again, just thank you for being in this position. But I'm going to ask you one question that I asked Perez. But this is as a general lawyer, as any lawyer who's just taken your about conflicts of interest. We've asked the department to appoint a special counsel, since they have a conflict of interest in enforcing subpoenas against the department. We've asked them to appoint, like you did, to go to court. We've asked for a special counsel to go to court since we have a disagreement. We think there's no excuse for them not to follow the law unless the president invokes it. They think they can do whatever they want. We've asked them to appoint a special counsel to go to court. And I asked Perez, and they said, no, they don't want to do so. I asked him, and I'll ask you, do you know of any situation where the entity with the conflict of interest gets to decide how to resolve the conflict of interest?
A federal district court judge who has a motion for recusal in front of him. That's one that comes to mind.
Is there any non-judicial official?
Probably not, but again, I'm not an oracle of all things of the world, so I can't answer that question conclusively.
But I just I don't know if you want to comment. Note for the record that we're in a similar position that you. We either would have been happy to go to court with the department or for them to comply with the law. But the department has chosen to do neither.
No, clearly, my attorneys very much made it clear, contrary to, as I said, some comic blogs, that I would have welcomed a motion to quash this subpoena. I would have been perfectly happy if that had been the outcome in regards to that subpoena. I would have let the court know that I have no objection to the motion to quash. But that never came.
Thank you. Commissioner Kirsnow.
Thank you, Mr. Chairman. Mr. Adams, would it be fair to say that one of the objectives of the Voting Rights Act, 11B in particular, is not simply to redress any particular harm or grievance of an affected individual, but also to act as deterrent? That is, the Department of Justice would bring a case to make sure that this type of conduct didn't occur on a repeated basis. Would that be fair?
Unquestionably, you know, especially given the sacred nature of what we're talking about, the right to vote, no question.
And then to what extent then would the fact that we have this video that's been seen by millions of people have any bearing on the department's determination to dismiss this case, well, to bring it in the first case, but then to dismiss it after some deliberation, apparently? That's
one of the saddest parts of this whole story, is so many young people are going to see, as I put it, we abetted wrongdoers and abandoned law-abiding citizens. Those messages percolate throughout a culture, and it's a tragedy that that occurred.
In 2007, Attorney General McCasey, then Attorney General McCasey, issued a memo issuing guidelines restricting communications with the White House, with DOJ with the White House in certain circumstances. Are you aware of who within justice, if anyone, would have communications with the White House regarding any type of dismissal of the new Black Panther case?
I have very little familiarity with what I call, or other people call inside the department, the Mukasey memos in regards to those communications. I may have looked at them one time and thought, well, that won't apply to me. I'm not going to have those communications anyhow, so I moved on to other more important things. But I don't have a lot of familiarity with those memos.
And just an observation, you made mention of the fact that whether or not the Department of Justice disputes the submission that you presented into evidence would be an indication as to whether or not they're engaged in or will continue to engage in equal treatment or equal protection of all individuals in the United States of America with respect to voting rights. Given your testimony today, I'd be astonished if they didn't dispute it.
Well, don't forget, they have options on how to dispute it. I made it clear that if they do anything other than object to the submission, they will be televising to anybody who knows this area of the law that they don't believe Section 5 applies to white victims. Now, they can go and do a more determination, or excuse me, a more information letter or a no determination letter. They could even go back to the federal judge with all of the inherent heightened risk of doing so to try to seek a stoppage of what's going on here. But they don't want Section 5 to be used for white victims, so it's not going to happen. Now, if they do it, I'm going to be thankful. I'm going to write a thank you note. You know, please do this more. But it's not going to happen. You can know July 14th. Look, they may go file something in district court, but every lawyer knows that that carries risks, that sending a letter saying we object under Section 5 doesn't. And they won't do the Section 5 letter because they don't want to help white victims in Noxubee County, Mississippi.
Thank you, Mr. Adams. Thank you, Mr. Chairman.
Okay, Commissioner Taylor.
Just one question, Mr. Chairman. Mr. Adams, could you share with the Commission the response, what I have heard described as the smearing of your good name in response to your willingness to speak candidly about these issues? Share some of that with us, if you would.
Well, you know, I don't want to necessarily get in too much of a fist fight, but it's curious how, you know, various things have been said, whether it's that I'm a conservative, which I guess is somehow disqualifying to tell the truth, or axe to grind. Listen, I loved my job. It was a wonderful gig. I was at the top of the federal pay scale. I couldn't go any higher. I got promoted 2 weeks earlier before I resigned. It's intellectually enriching to do this work. For somebody to smear as opposed to argue the merits, I guess when that's all you have, that's what you have to do.
Okay, Commissioner Harriet.